Welcome, everyone. This is the 10th and final session of our book club on the Federalist Papers. Before I go into the first slide, what I want to do is make comments on 2 points that I think are critical in understanding, especially Federalist 78 and its relationship to all of the other papers that we've looked through. If law students read any of the Federalist Papers, what they read is at least Federalist 78. In a few classes, they might read more than that. In many classes, they don't even read that. But in some classes, the purpose of Federalist 78 is to enhance the argument by some professors that really it was intended from the beginning that the Supreme Court be supreme over the other two branches. But if you've understood everything else up to this point and you watch within the Federalist Papers, in particular 78, you'll find out this is not true. Now, second point is that many conservatives and libertarians read Federalist 78 and they wonder, how could Hamilton have gotten it so wrong? Well, guess what? He didn't get it wrong. You say, that's not true. You would tend to agree probably with the arguments made by Brutus, because Federalist 78 is a response to Brutus. Entertain, please, the possibility that both Publius, Hamilton, and Brutus were correct after the 14th Amendment, or at least after the 14th Amendment was applied to the states. Why? Because if you look at the case law in your case books, the section on the rights area continues to grow. The section on structure doesn't grow that much. And that is what Publius is addressing. So let's turn then to Federalist 78 and to the first one. So I mentioned last time about appointments, and I got ahead in a way to appointments and talking about judicial appointments. First, he says that on appointments, the same is dealt with the same as that of appointing the officers of the Union in general, and that was in the previous essay. Why is that important? Because as Publius says in the previous essay, the reality is that the appointment is basically the president's, subject to a negative by the Senate, yes. But it's important that it not be the Senate's choice for a couple of reasons. It should be the president's, one, and two, that when it comes to impeachment and other matters, the Senate ought not to be really responsible for it. Well, as I mentioned, Professor Larry Tribe years ago, when Reagan was president, attempted to argue that the two, the Senate and the president, had an equal voice. That was not the point at all. And certainly when it comes to judges, it's not the point. Executive officers and judicial officers, both officers of the United States, are treated for appointment purposes in the same fashion. The elements of and reasons for judicial independence. He talks about tenure here, the second point, their duration in office, and that along with their support and precautions for their responsibility. We know that Congress cannot reduce their payments, although Congress can inflate the currency, which has the same kind of effect, but there's no way ultimately to control that. But the duration in office is what creates the independence of judges. Why is this important? Because many argue about independence of judges in a much broader way. The term independence of judges is a term of art taken from the British judiciary. That is, it involved tenure during good behavior and undiminishable salary. That's what constitutes independence. Congress and the president have the ability to do other things that might negatively impact the judiciary. It doesn't mean it infringes on their independence. Also, some judges in state courts where they are elected don't like this comment, but elected state judges are not, quote, independent. Now, I imagine most state judges, if they hear that, would get very upset about it and say, of course, I'm independent. It has nothing to do with your particular independence per se. It's a protection for the likelihood that someone will not be influenced by outside factors, including voters. That's what it's all about. That is what is meant by independence. So the Supreme Court's authority depends not on force, but on judgment. And a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution. This is where conservatives think, you got it all wrong. No, listen more. It will be least in a capacity to annoy or injure them. It may truly be said to have neither force nor will. Now, many in the Federalist Society quote this part of this text in the sense that they shouldn't have force or will. But continue. This is the part that is rarely quoted. But merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Some judges take it for granted that, of course, their judgments will always be enforced. But remember, in Marbury, Chief Justice Marshall was acutely aware that President Jefferson would not enforce any judgment which ordered Secretary Madison to do something that the president didn't want him to do. That was very clear. Now, we'll talk more about Marbury as we go along. And sometimes the judiciary seems frustrated that they can't have this power. And in one case in the Supreme Court, the Wheaton case, which Justice Scalia always included in his course, he was very excited about and opposed to that result, where the court upheld in a particular case only, though, the appointment of a prosecutor. As Justice Scalia said, that violates separation of powers. But there is always the desire on each of the branches to be able to exercise the power of the other branches. But separation of powers is designed there to prevent that. The weakest branch and the consequences of that, several important consequences. The weakest of the three departments of power, here he quotes Montesquieu. So he's not just making this up on his own. It can never attack with success either of the other two, and to enable it to defend itself against their attacks. Though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. Now, here we have a question, and again, as predicted, there's going to be an objection to this. So, Raymond objects. I wonder if he would still defend the assessment of the judicial branch if he knew the current place of the Supreme Court of the United States in American culture. It is striking from today's vantage point that a founding father was more concerned with a runaway legislature than a runaway judiciary. Well, they certainly were, and why weren't they concerned as much about the runaway judiciary? The judiciary, one of their main purposes was to enforce congressional legislation as long as it was constitutional. The choice in a federal system, they said in the convention, was between military force and the rule of law and judges enforcing it. They opted for that. That's a big part of it. So we're going to go on and again realize that prior to the Civil War amendments, in particular the 14th Amendment, there wasn't much occasion for the federal courts to intrude into matters of domestic law, for better or for worse. For worse was on the question of slavery, but for better on all these other things, the states actually were able to shape their own society, and the things that have become possible since then clearly were not possible before the 14th Amendment. Remember, Barron versus Baltimore clearly stated, as it must and should have, that the Bill of Rights did not apply to the states, only to the federal government. So, what if the judiciary is dependent on another branch despite nominal separation? This is what I want you to consider. that the judiciary today, and since the New Deal court began, has changed the rules of the game. And how did they do this? Only with cooperation of the Congress. You had progressives in both branches. I submit to you that the courts were, at least for most of that period, quote, dependent on the Congress. Prior to the New Deal, and in the early part of the New Deal, progressives were issuing blistering criticisms of the federal courts. Once, however, progressives got control of the Supreme Court, things changed. And after a while, it was inappropriate to criticize the Supreme Court in the minds of some progressives, at least. That change was because, in large part, they knew the court was doing the bidding of Congress. That's why in the 90s, when for the first time in 40 more years, the Supreme Court held two congressional statutes unconstitutional when Congress was asserting its power under the Commerce Clause, that a number of senators were outraged. Why was the court no longer doing its bidding? Moreover, during that whole period of time, and still, most of what the Supreme Court has been doing has affected the states, not as much the other branches of the federal government. I mean, so long as the judiciary remains truly distinct from both the legislative and the executive. For I agree that there is no liberty if the power of judging be not separated from the legislative and the executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. That is, all the effects of such a union must ensue from a dependence of the former on the latter, notwithstanding a nominal and apparent separation. We have a nominal and an apparent separation in many cases. Remember when the Supreme Court decided to back off of invalidating federal statutes and turned its attention to the states. Because why? After the 17th Amendment, senators were not there any longer to protect the states. Fast forward to the 70s, 80s, 90s, and today, senators on the left expect judicial nominees to continue the rights revolution, which is really, in some cases at least, an incursion on state power, which is not at all legitimate. Notwithstanding a nominal and apparent separation, that as from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches, and that as nothing can contribute as much to its firmness and independence as permanence in office. If you think today that the federal judiciary is not weak, consider the proposals to add 3 Supreme Court justices. If the left is able to eliminate the filibuster, then vote 3 seats additional so that there are not 9 but 12 justices, and the Democratic president agrees to that and signs it, what can the Supreme Court do about it? Absolutely nothing. That is their weakness. What has kept them in the past from that problem during FDR's administration was public opinion. Would public opinion defend the court as much today? Hopefully, but certainly the left today is more bold and stronger than it was back in the 30s. And what distinguishes our country from countries that say they have followed our Constitution is that we don't engage in that kind of third world activity. You saw it in Venezuela. You've seen it several times in Ecuador. We have solidified it into our constitutional culture. Limited constitution with restraints on the legislature requires judicial independence. The complete independence. Why is it required? A limited constitution. Because there are things denied to the legislative power. And those in legislatures do not like to be told no. They do not like to be told that they don't have the power to do something. And in fact, there are cases in which, even though the Supreme Court has ruled a certain way, they ignore it. And I've mentioned already the so-called line item vetoes. I'm sorry, not line item vetoes, but legislative vetoes. In fact, Congress still engages in those and uses pressure against the agencies to make them effective. And it's done in such a way that effectively the president is unable to do much, if anything, about it. Claim that the courts will be superior to the legislative branch. This is discussed several times. This is the argument that Brutus is making. He says there's an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. That's the argument. But the Constitution is superior. It only delegates certain powers to the legislative branch. Now, this is really grounded in the Federalist understanding of popular sovereignty. And that's why the preamble says, "We, the people of the United States," and why the Anti-Federalists objected, it should have said, Patrick Henley, "We, the states." So it is in this notion of popular sovereignty, where only the people are sovereign, which I once thought was merely a myth. It's not a myth. The people parcel out their power to different governments as reflected in different constitutions. So when a delegated power, the construction of which is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. We accept that notion. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above the master. This argument seems to have been lost by many in our country, but in particular, Professor Randy Barnett, my good friend, he's made this very notion about the agent relationship very clear in his work. And this is a concept that we have to bring back. They are our servants. The claim that legislative power conclusively determines constitutionality of its acts. That is the case in France. That is their notion of separation of powers. And that under that, the parliament decides what's constitutional. Judges are not there for that. Judges are there to do the will of the legislature. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. And we all know that quite often what members of Congress do does not accurately reflect the will of their own particular constituents. Now the members try to minimize it because they want to be reelected. But we know the power that comes from the legislative leaders and the pressure they put on moving people to vote for things that they don't want to vote for. This happens under both Republican and Democratic administrations. The Constitution as representing the intention of the people. This is key, and this is what we'll see Marbury is based on as well. It is more rational to suppose that the courts are an intermediary body between the people and the legislature to keep the latter within the limits assigned to their authority. Now notice, the interpretation of the laws is the proper and peculiar province of the courts. I'm going to come back to that in the next slide. They must be regarded as judges of fundamental law. Until our Constitution, constitutions were, except with one exception, they were political, purely political. The idea that a constitution is law is really very new. And so judges are ruling on law. To ascertain the meaning as well as the meaning of any particular act proceeding from the legislative body. The Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Well, that undermines the whole notion of the living Constitution. How can you say that judges are supposed to update the Constitution on their own with their sense of what they think the people want? And you're talking about current majorities, but not even that. You're talking about current opinion. And as Justice Scalia used to say, it ends up being the opinion of elites. Now, here's the sentence. So, Justice Scalia used to always say that Chief Justice Marshall, quote, plagiarized Federalist Marbury, the part in Marbury where he explains what we call judicial review. It wasn't called that back then. And so here's Marshall's statement. It is emphatically the province and the duty of the Judicial Department to say what the law is. Federalist 78, the line that I previously pointed out. The interpretation of the laws is the proper and peculiar province of the courts. If I had time, and I've done this in the past, I'd go through and line up all of the paragraphs and the arguments from Marbury against the paragraphs and arguments from the Federalists. It turns out that Marbury makes every argument made in that section of Federalist 78, and it adds only one argument about the oath that judges take. The structure of the argument in Marbury. Marbury, all the law students and lawyers know Marbury very well, but maybe they haven't fully thought about it in a stripped down version. The issue is whether the commission should be delivered to Marbury. He wants this commission as a judge, and he doesn't have a commission, so they're not going to put him on the payroll. So the way that Marshall does this, he first says, does Marbury have a right? Yes. Where's the right come from? It's not a natural right. It's not a Bill of Rights. It was the Constitution provides for nomination by the president and confirmation or not by the Senate. Those occurred. Therefore, he has a right. The commission is just ministerial. Is there a remedy? Yes, it's mandamus. Why? Because when a duty is clear and there's no discretion, mandamus is an appropriate remedy. And he says that he could mandamus Secretary of State Madison. Of course, Madison didn't show up. So that's going to be a message that we're not paying attention to what you say. Can this court grant the remedy? No, why not? And you can debate whether Marshall did or did not interpret the Judiciary Act provision correctly, or whether he stretched it to reach the result he wanted. In any event, the court says it lacks jurisdiction because the provision in the Judiciary Act violates the language in Article 3 regarding original jurisdiction of the Supreme Court. Note that President Jefferson contended that Marshall should have only said that the court lacked jurisdiction. Well, that certainly is the common law approach, but in the common law approach, the highest court of the judiciary is it's a chamber of the, or was a chamber of the legislative branch, the parliament. But in our country, the judiciary is separated. But remember also Federalist 51, where Madison said, it's essential that each branch have a will of its own to protect itself, the weaker branches, and in doing so, they are protecting the rights of the people. Now, what Marshall did was to flip the normal order to make an authoritative statement. Now, what's interesting is prior to Marbury, or certainly under the Chief Justiceship of Jay, the court wasn't doing very well. In fact, Jay resigned because he said this court will never amount to anything. Well, Marshall knew how to make it amount to something, but not the way modern judges and law students and law professors think. Think about it. This one decision establishes the authority of the court. And what did he say? We lack power. He establishes authority by saying we have no power. Today, people confuse power and authority. They're not the same thing. The reason why we have judges is to insist on the authority sometimes against the power of the political branches when their power is exercised in a way that violates the Constitution. By the way, what really upset Jefferson was not judicial review, just, again, the term. Jefferson thought, of course, that the judiciary had to interpret the Constitution, but he also thought the other branches should interpret. That's correct. But he didn't think that the interpretation by the court was any better than his interpretation. That's why the language just quoted on the prior slide from both the Federalist and Marbury is all about the preeminent role that the court has. That doesn't mean that it is supreme over the other branches. It means that it is equal to the other branches and is not going to let it be run over as Jefferson wanted to do. The judiciary not superior to the legislature, the people are superior to both. It only supposes the power of the people is superior. They ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental. Unfortunately, with the advent of the notion of the living constitution promoted by the progressives, this idea that the Constitution is fundamental, unchanging law, subject only to amendment, has been lost, and generations of law students and therefore lawyers believe that in fact this is the way it's supposed to be. Nothing could be further from the truth. Why? Well, you can blame most of this on Justice Holmes. He's merely representative. But Holmes attacked the notion that what judges said was not the law. Of course, he said, opinions are the law. Now, that is not what Story wrote for the whole court. And Story and Holmes, as I mentioned, they are the antithesis of each other. This idea that what judges say is law just by saying it in an opinion and it's equal to legislation in that sense is an idea that was not there at the beginning. It's invented by the progressives. Now, inadvertently, maybe Marshall was, in a way, contributed to this. Before Marshall, the British judges and even the Supreme Court before Marshall issued individual opinions. We call them seriatim. There was no necessary controlling opinion of the court. There was a controlling judgment. But Marshall wanted to enhance the authority of the court, and he did so by getting almost as often as he could unanimous opinions. That certainly gave the opinions more authority. They ought to regulate their decisions by the fundamental laws rather than those which are not fundamental. And in Marshall's opinions, as I tried to show previously in McCullough and here in Marbury, and as confirmed by Justice Story in his commentaries on the Constitution, it was all about the text of the Constitution, the Federalist Papers, and the decisions of the Marshall Court. They were all in sync. In terms of the power of the court, remember what Lincoln said, and we'll talk more about this. Lincoln made a distinction, as he should have, between final court judgments, which control the parties, and precedent, which is not necessarily binding. With contradictory laws following, the later in time is only a rule of construction. Normally, if you have two statutes that are in conflict and you can't reconcile them, the later in time controls. And as he says, this is a rule of construction by the nature of the thing. Well, if you're talking about a democratic society or even a relatively non-democratic society in which you have legislation, the current legislation is deemed to have taken place against the background of the other. So you have no choice, in effect, but to give preference to the later. That's a rule of construction which is flipped in the case of the Constitution, because the first and the most important becomes the Constitution. Therefore, it is the standard by which legislation is judged. It doesn't change, And if the legislation, although later, it's an inferior form of law, it has to give way if it's in conflict with the Constitution. The claim made by others, again, that the courts may substitute their own will to that of the legislature. And this is often complaints that people make today, but they also made them at the time of the Marshall Court. But remember, most of what the Marshall Court was doing, at least the big cases, when you think of McCullough and Gibbons, were about legislative acts. And they weren't saying that Congress had to do these, enact these statutes. In fact, it was the other way around. It was simply saying that what they did was constitutional. In the case of the bank, later on, what the Congress did was not continue the bank. And the Congress was free to do that. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequences would be equally the substitution of their pleasure to that of the legislative body. That's really what we have today in many cases. I mean, the notion of the living Constitution authorizes, it says, or proclaims that judges ought to be substituting something to the text to update it. If it proved anything, it would prove that there ought to be no judges distinct from that body. Permanent tenure is the justification blocking legislative violations of the Constitution. The bulwarks of a limited Constitution against legislative encroachments justifies permanent tenure. That was certainly true up to the 14th Amendment. And that other than Dred Scott and Marbury, there were not any other occasions in which the Supreme Court invalidated, declared void a statute of Congress. Now, afterwards, during Reconstruction, Chief Justice Salmon Chase's period, there were at least 7 or 8 cases in which the court declared an act of Congress unconstitutional. Now, that was reflective of a period of time where the legislature was quite exercised about many things and was feeling its power very strong. And it wasn't functioning completely because it was not fully staffed. It didn't have all the members from the states of the South. And therefore, there wasn't as much opposition as there would be later on. Judicial independence protects the rights of individuals. The reason I have this is because I wanted it to contrast it to the essay number 84, which we'll be going to, because he says we don't need a Bill of Rights. Well, if we don't need a Bill of Rights, what rights of individuals are we talking about? Well, we saw the right of Marbury. That was one of the rights. It wasn't on the Bill of Rights or anything else like that. It was in the Constitution. But, and this was a controversial question at the time, courts assumed, at least the Federalist courts did, that the common law was part of the law that they were applying. And in the common law, there are many questions, property, tort, etc., that involve the rights of individuals. The Constitution binds all until changed, but it's difficult for judges to resist a majority. Until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding upon themselves collectively. And judges are in that collectivity. It would require uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it had been instigated by the major voice of the community. Now note, compare this back to Federalist 10. It's part of the purpose is to break up the power of majorities. Indeed, I often say there is no such thing as a majority in the United States. We have multiple majorities. Every member of the House of Representatives is elected by a different majority. Every senator is elected by a different majority. The president is elected through the Electoral College, different majorities. The Supreme Court is appointed usually, except in the case of Washington, by different presidents reflecting different majorities. Temporary appointments of judges would be fatal. There are some today who would argue for such a thing. The difficulty is, and he lays it out, I think, very well, that inflexible and uniform adherence to the rights of the Constitution and individuals we perceive to be indispensable to the courts of justice can certainly not be expected from judges who hold their offices by a temporary commission. Periodical appointments, however regulated, or by whomsoever made, would in some way or other be fatal to their necessary independence. If the power of making them was committed either to the executive or legislature, there would be danger of an improper complacence to the bench. The issues have come up, for instance, administrative law judges who shouldn't be called judges at all, because the Constitution provides that all judges are to be life tenured, but they are well known to be compliant with those who are in charge of the executive department. Yes, they will claim their independence. I understand that. But it has been the case that certainly in the case of the SEC, that one past administrator wanted to move certain actions out of federal court into cases before ALJs because they were losing too many cases in federal court. Why do they expect to win more in their own, quote, courts? They're not courts. They are administrative offices, ultimately under the control of the executive branch. Only few will have the learning and integrity to deal with the growing body of law. The standard for approval of judges used to be, even when senators didn't want to abide by it, they thought bound to find fault if they didn't like a nominee by saying that the person wasn't learned enough or that the person lacked integrity. So often they went after the integrity issue. I mentioned earlier a question about the Nixon administration, where it was only on the third time around that Nixon was successful in getting Justice Blackmun approved by the court, but for the court. Earlier, as I said, Senator Hart said they had knocked out the first person on an alleged impropriety. Of course, it turned out, as many knew, that the so-called impropriety, one, wasn't an impropriety, and two, many other judges were also doing the same if it was an impropriety. And he said the only thing we have on him is he's stupid. Well, that should have been disqualifying, and that should have been the basis on which they attacked him. That would have been legitimate. But the notion here is that there's going to be such a voluminous code of laws, which is one of the inconveniences necessarily connected with the advantages of free government. That's certainly true. And unfortunately, the American people both want more law and they want things simpler. Not possible. But it has gone much beyond that, as I've noted before, in terms of the number, not only of statutes, but the number of regulations and such, that nobody can really know the law. And therefore, we really don't have a rule of law as understood by the founders. To avoid an arbitrary discretion of the courts, it is indispensable that they should be bound down by strict rules and precedents. How do you square that with the living Constitution? You can't. Which serve to define and point out their duty in every particular case that comes before them, and it will readily be conceived from their variety of controversies which grow out of the folly and wickedness of mankind, that the records of those precedents must unavoidably swell to a very considerable bulk, and must demand long and laborious study to acquire competent knowledge of them. In fact, today, nobody's long study would be adequate to comprehensively understand all the federal statutes that there are. Hence, it is that there can be few men in the society who will have sufficient skill in the laws to qualify them for the station of judges. We hear often that there are not enough federal judges, and the Democrats are proposing more judicial appointments to positions in the appellate courts. The reality is what's happened is by Congress going well beyond the scope of its authority, we have increased greatly the number of federal judges. And in doing so, you're not likely to meet this standard. So many extremely well qualified lawyers can't afford to take the pay cut. And so often, some of the people who want it, not all, but some of the people who want the position may not be the best lawyers. So, hence it is that there can be but a few men in the society will have sufficient skill in the laws to qualify them for the station of judges. And making the proper deductions for the ordinary depravity of human nature, the number must be still smaller of those who unite the requisite integrity with the requisite knowledge. Moreover, what Congress has shoveled onto the federal courts and what the federal courts have taken on themselves in terms of administering prisons and other state institutions has turned the judiciary into something it was never intended to be. As time goes on, some of the more qualified people, even if they are inclined to be a federal judge, would not particularly like it if you're a Court of Appeals judge and what you're doing is reviewing so many sentences because there's so many criminal cases. And of course, criminal cases, the criminal power is supposed to be left in the state. But the federal government has decided that it wants to get in to so many criminal cases, and it has dumped all of that on the federal courts, never designed to handle these things. So Federalist 81, we're continuing with the tack that the court should not really be as independent as it is. The argument here is the authority of the Supreme Court must, Court of the United States, which is to be a separate and independent body, will be superior. We've heard that. The power of construing the laws according to the spirit of the Constitution will enable that court to mold them into whatever shape it may think. Okay? He goes on and argues this is false reasoning. It's false reasoning in the first place. There's not a syllable in the plan which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. The idea of the spirit of the Constitution is exactly what the progressives brought to us. The Constitution ought to be the standard of construction for the laws, and that wherever there is an evident opposition, the laws have to give way to the Constitution. This doctrine is not deducible from any circumstance peculiar to the plan of the convention, but from the general theory of a limited constitution. Well, since the progressive era, the limits on congressional power have been basically taken away. And in large part, we don't have a limited constitution. Indeed, why should courts say that there's a presumption to the constitutionality of a federal statute? If we know that legislative bodies are very inclined to encroach on the Constitution, and if it is a limited constitution and their power has to be exercised only in accordance with the enumerated powers, shouldn't the burden be on Congress and those defending a statute to explain why it falls within the parameters of power? That would seem to follow logically from what the basic premise of a limited constitution is. So, from John Madigan, it seems to me that we have seen the Supreme Court ignore this, instead do what the justices decide they want to do to enact social change. Well, one, I've said that that's largely related to the 14th Amendment. The 14th Amendment was properly enacted. It has been, I think, improperly construed in many ways. For one thing, the 14th Amendment, which makes distinctions between citizens and other persons, instead of going under the Privileges and Immunities Clause, as Justice Thomas says and Justice Black said, Instead, we've gone under the Equal Protection of the Laws Clause and changed that to an Equality Clause and the Due Process Clause. All persons are entitled to due process. All persons are entitled to the equal protection of the laws, but not all non-citizens. No non-citizen is entitled to the privileges and immunities of U.S. citizens. That's the distinction made in Roman law between the jus civile, the civil law, which was applicable to citizens, and the jus gentium, the law of nations, which was applicable to everyone. So he says the courts have upset the balance of separation of powers. Indeed, they have, but they haven't done it alone. It has largely been by its dependence or cooperation with Congress in expanding the powers of Congress and therefore expanding its own powers at the same time. Members of the legislature generally are not fit to be judges. In many states, you have people going from the legislative branch into elective or appointed judges, and you can make your own judgments about that in different states. Some state judges do stand out and have been appointed to federal courts, and they've done quite well. But if you look at it as a general matter, I think there's a lot to what Hamilton was saying. On account of the natural propensity of such bodies, meaning legislative, to party divisions, in other words, factions, there will be no less reason to fear that the pestilential breath of faction may poison the fountains of justice. That's what he's worried about. The habit of being continually marshaled on opposing sides will be apt to stifle the voice both of law and of equity. There are different people who have made it to the judiciary who have a certain sense often that they seem to be acting as if they were legislators instead of judges. And of course, the whole notion promoted in law schools that judges should be policymakers certainly encourages this. The distinction between judges and future legislation to change precedent. It is not true that the legislatures of the particular states can retry the exceptional decisions of the respective courts in any other sense than they might have done by a future legislature of the United States. Remember, this is before the 14th Amendment. And what we're talking about is the court reviewing acts of Congress. And what were the acts of Congress? There were four areas where the power of the federal government was devoted: foreign affairs, military defense, international trade, and trade among the states. It is largely, we know from the case law, been devoted to trade among the states. And what the court did was to uphold most of what the legislation was in terms of regulating commerce among the states. And it wasn't that much in the way of legislation. It's only in the early part of the 1900s, indeed the first decade, in the so-called lottery cases, in which the court actually blesses the idea that the Congress can go beyond as long as it is doing morally good things. That is really the beginning of the expansion, certainly in the area of criminal law and much of the regulatory front. I asked whether this statement is still true. What about Dred Scott? What about Lincoln's response? Particular misconstructions and contraventions of the will of the legislature may now and then happen, but they can never be so extensive as to amount to an inconvenience or in any sensible way to affect the order of the political system. Well, the Dred Scott decision in 1857 certainly did. It was a major contributor to the breakout of the Civil War. So it didn't happen then. Why is he saying this? He says from the comparative weakness and from the incapacity to support the usurpations by force. Remember, at the time of the convention, even the southern states, if you read the notes, Madison's notes, they thought that slavery was going to die out after about 20 years, that they were given supposedly to make a transition. It's later on, as I mentioned before, that defenders of slavery begin to make a much stronger so-called moral argument. It wasn't a moral argument, but they claimed it was. In any event, that changed matters, and that divided the country to the point of war. We are again greatly divided in this country, and again, in part, due to what the courts have done. Lincoln's argument in Dred Scott was reflective of what we just read on the previous slide. We can't free Dred Scott. There's a final judgment against him. But as to the precedent, we do not have to honor the precedent. And here is the Congress to vote against anything that was dependent on Dred Scott. Impeachment is a complete security, he said. Well, Jefferson found out and said it was just a scarecrow. It didn't work when he tried to get one of the lower court judges impeached. And Marshall was probably next on the hit list had that succeeded. Impeachment is not supposed to be easy. In large part, impeachment is a way for the House to reflect the passions of the people, and it is for the Senate to have a cooler view of all of this. In any event, the impeachment, in reality, as I've said before, most of the impeachments in our history have actually been against federal judges, and they're the ones that have been removed. Nobody else. Federalist 84. Now, this is one thing that a lot of people wonder about. There's a complaint that there's no Bill of Rights. Yes, we know about that. But he notes that several of the states, they're in the same predicament. Moreover, he says the Constitution has some provisions that are in the nature of rights. The rights included, I won't go through this, it's limitations on impeachment, difficulty of suspending habeas corpus, no bill of attainder, no ex post facto law, no title of nobility, the emoluments clause, criminal jury trial, limitations on punishment of treason. All of those are forms of rights. But the anti-federalists argue, well, if you gave those rights, why not more? Well, first of all, these are the ones most likely for a legislature to want to override. State constitutions reference common law. Part of the argument was about the common law, but as he points out in this one, the common law was in all of those states was enacted or referred to by statute in order to make clear that the basic law of England continued as modified. Now, unlike the French Revolution, which tried to tear up the law, the original arguments for our revolution were about maintaining and preserving the rights of Englishmen. And that's what wound its way into the state constitutions that had bills of rights. They wanted to state those rights. And even the anti-federalists did not think of them as judicially enforceable necessarily. They wanted it there as a reminder of what the ancient law was. But when a Bill of Rights is put into the US Constitution, it's different. Unlike these statements about the state constitutions, it was their intention to enforce these rights, not merely to have them as aspirational or hortatory. Historically, bills of rights are stipulations between a king and a subject. That's the origin of Magna Carta, which we still cite as the basis for Anglo-American notions of rights. But these rights in the Anglo-American world have, until recently at least, been largely procedural rights. Indeed, the common law rights dominate the Bill of Rights, beginning with the Fourth Amendment, the Fifth Amendment, Sixth Amendment, Seventh Amendment. A detailed list of rights is inappropriate and, he says, even dangerous for a limited constitution. Now, this seems to many people amazing that he was against a Bill of Rights. And I say Publius because Madison was also against the Bill of Rights. And you say, well, how is it that Madison ended up proposing a Bill of Rights? It was part of the argument he made in the Virginia Ratification Convention to undercut Patrick Henry, which he did. But of course, Madison had to get elected to propose it. When he proposed the Bill of Rights in Congress, his fellow members of Congress were not terribly interested in doing anything about it. And ultimately, he prevailed by saying two things. One, it won't do any damage. Why? They gutted the right that many of the leaders of the anti-federalists wanted, which was the clause I mentioned before, that was in the Articles of Confederation about powers only expressly given to the federal government. So at that point, Madison said, it won't hurt, and what it will do is politically, it will satisfy everyone. And as Wilson attested to, after the Constitution was fully adopted, then it was completely supported. That's what Madison wanted. And it is only beginning with the progressives that we begin, well, no, it begins earlier, but there's a real undermining of the original Constitution. He goes further in the second paragraph and says, I go further and affirm that a Bill of Rights, in the sense and to the extent they are contended for, are not only unnecessary in the proposed Constitution, but would be even dangerous. They would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than they were granted. Think of the police power. The federal government was given no general police power, yet we have hundreds of agencies in the federal government that have taken police powers, some of whom who use the term police, and many that have weapons and police power de facto. But if you look at the Bill of Rights, we have all these protections against the prosecution of and investigation of criminal cases. So you look at that, you think, well, of course, the federal government must have a lot of police power. It doesn't. That validates exactly the point he's making. Further up, which I didn't read about the minute part, where do you stop? How many rights do you list? As Justice Scalia used to say, we have a very poor Bill of Rights compared to those of the Soviet Union and Iran. They're much more full. The Bill of Rights, as Justice Scalia often said, is merely the icing on the cake. Without separation of powers and federalism, it wouldn't be enforced, just as bills of rights in other countries, many other countries, are not enforced. There are definitional problems, and I'm using this as an example in particular on the liberty of press because of the issues currently about social media. I infer that its security, whatever fine declarations may be inserted in any constitution respecting it, must altogether depend on public opinion and on the general spirit of the people and of government. We have specific protection of religion in the First Amendment. But as you can tell, during COVID, there have been a lot of attempts that have been dealt with by the Supreme Court from states where governors and states have seemed to give much less attention to a specific right in the First Amendment, which was among the most important for the founding generation. It largely often does depend on public opinion. Certainly, it is good to have the Supreme Court doing this, but remember that at the time, before the administrative state, the federal government didn't have as much power, and states didn't have as much power. Yes, they had general powers, but the amount of money that they're getting from the federal government, which allows them to build power without directly as states taxing their own people, has contributed to the administrative state, not only in the federal government, but in the states themselves. So, point from Cody, he says, today every single right mentioned in the Bill of Rights is subject to limiting regulation. Free speech is regulated in certain scenarios. Free exercise is restricted in certain scenarios. The right to carry firearms is limited in certain scenarios. It seems as though the inclusion of a right in the Bill of Rights functionally resulted in a direct invitation for the federal government to restrict or hamper the right. The left often claims that it wants to protect everybody's rights. What happened to the Second Amendment? Somehow that doesn't count. They're very selective. Of course, most people are selective, but it's a different thing when you try to suppress the people of their rights when in fact it's as clearly stated in the Constitution as it could be. Another point that opinion still has to support these rights. The structural Constitution is itself a Bill of Rights That's the whole point. Without separation of powers, you really don't have the protection. It comes back to the first 51 essays, and in particular, those statements in 51 about giving to each of the three branches a motive to defend its institution and conflicting motives between the federal government and the state governments clashing with each other that protect rights. Running on time, there's still something I want to get to. The executive and legislative bodies of each of the states will be so many sentinels. No, they haven't been for a long time, but especially since the 17th Amendment. The principal departments in the new government will be like those in the Confederation. Well, we know that that's no longer true because of all that Congress has passed by way of legislation, which has created additional departments. What I want to end with here on the Federalists before I turn to what we're going to be doing going forward. Federalist 85, I didn't assign it, but here Publius quotes Hume. Hume was an atheist philosopher from Scotland who was quite famous in the Enlightenment as a critic of the so-called state of nature political philosophers, Hobbes, Locke, and Rousseau. In other words, he was against their rationalism, their theory. To balance a large state or society, says he, whether monarchical or republican on general laws, is a work of great difficulty. Remember, some of the anti-federalists said just that much. You can't balance this thing. It's too complicated. But here is Publius's attitude. The judgments of many must unite in the work. Experience must be the guide, must guide their labors. Time must bring it to perfection. And the feeling of inconveniences must correct the mistakes. And that's what happened with slavery, which they inevitably fall into in their first trials and experiments. What those in the cancel culture don't understand is that human history is all about learning from failure. And if you wipe out the learning from failure and the consequences, both good and bad from it, you are going to be submitting yourself ultimately to tyranny. There is no history. There is no experience. There is some kind of theory. And what we are seeing in this country, because it is declared by the leaders of BLM and Antifa, they are trained Marxists. That is a quote from a BLM organizer. If people do not understand what this country is going through at this point, it's time to read the Federalist to understand where we were, what created this country, and what we are in jeopardy of losing. So going forward in the fall, beginning on August 24th, Peter Redpath has asked me to do another series, and I want to do it on argumentation. We haven't selected a title as such, but as you may know or remember, that Justice Scalia was not only a wonderful writer. When he wrote, it was an argument. And he was also a fun speaker. And he argued in his speech. He was always arguing. And our constitutional system assumes a lively system of public argument. That's how we make policy. And the effort, not only by cancel culture, but by the social media giants to suppress that, is a serious threat to democracy. If you're interested in being reminded of the start of this before August 24th, just send an email. You don't have to write anything on it, but just send an email to our address that I've given you before, and Ron will put up after this so that you can send it. And in closing, I want to thank not only you, but Peter Redpath and Kate, his assistant especially, but also Bram, our director, and the rest of the technical team, and the students who have asked a number of really good questions. So thank you for joining us for these 10 sessions, and I hope that you will be interested in joining us on August 24th.